Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers seatbelt laws, interference, and traffic stops, and is brought to us by Ras Binghai Trufaya's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, Surfshark. We all know Surfshark is a premier VPN service that offers its users security, privacy, and peace of mind at a fraction of the price of competing brands. But did you know that a Surfshark subscription also includes a host of other features designed to enhance your browsing experience? One of the many perks of a Surfshark membership is that it allows its users to bypass region restrictions on popular platforms like YouTube and Netflix and view content that's not normally available in your country. Thanks to Surfshark, I can browse all the shows on my favorite streaming apps, even if they were removed from the US catalog. Right now, Surfshark is offering the ATA community an 83% discount with an additional 3 months completely free when you use code AUDIT. With 24-hour customer service and a 30-day money-back guarantee, you have absolutely nothing to lose. So click the link in the description to claim your exclusive offer now. Thanks again to Surfshark for sponsoring this episode. In a video posted on December 23, 2019, an officer pulled over a vehicle being driven by the daughter of the owner of the Ras Binghai Trufaya YouTube channel, who we will refer to as Mr. Trufaya. Very little additional information is available about this interaction, but we do know that it occurred somewhere in Texas. After the officer stopped the vehicle, he approached Mr. Trufaya's passenger side window, and Mr. Trufaya's daughter recorded the encounter from the driver's seat.
Do you suspect me of a crime, sir?
I'm telling you.
You suspect me of a crime?
You did not have your seatbelt on from what I observed. That's why I made the traffic stop. In the state of Texas,
okay,
you have to have, every passenger has to have a seatbelt on.
And I have a seatbelt on, as anybody in the video.
You may now.
Sir.
I didn't see it.
Sir, what I think's happening here is you're baiting, you're looking at me, and you're judging me by appearance, and I would rather a supervisor be on here because I know my rights. There's no supervisor.
No, I don't have a supervisor.
Okay, well, we're live on footage here, and I do know at this point that unless I'm suspected of a crime, a judge needs to sign a warrant for you to go any further than where you're going.
I'm telling you.
Am I suspected of a crime?
I did not observe a seatbelt on you.
That's not a crime.
Which is an offense under the Texas driver's code. You must have a seatbelt on. Everybody in the vehicle must have one on.
I get that. That's not the issue here. The issue is here. You have no right to ask me for my ID.
You didn't see it. Sure. You said he had to have it on.
If you did, you were behind us. You pulled up. You peeked in to look at me, and then you pulled us up. I'm sorry.
What was that?
No disrespect to you, sir. I'm telling you.
That's really proper in front of your kids.
Sir, okay, good try. The issue is you're not being honest, so I'm going to call you on it, sir. Someone.
Your father, is that what he said?
That's right.
If you could convince him to just give me that information, it'd be so much easier for you guys, and we'd get you on down the highway.
Sir, you didn't even ask the driver once for her license. You didn't ask for registration.
No, I did. I asked for the driver.
She tried to give it to you.
And I said I don't need it now.
You need mine because you looked at me, sir. That is looking at me by discrimination on camera. You just admitted it. Anything that you're doing right now, for what? For what crime?
Wearing the seatbelt.
For what? You're going to detain me for not wearing a seatbelt.
I can actually take you to jail for it.
I keep confusing the issue. This is looking at me and discriminating against me and pulling us over for no other reason.
That's unfortunate.
There's no way that you can say otherwise. We watched you pull up. It's all on camera. You were in front of us. There's no way you didn't see the seatbelt on me because it was on me, sir. This is all an excuse. This is discrimination.
Your seat was laying way down. The seatbelt was not coming across. It was laying down this way. It's okay.
The officer claims that he pulled Mr. Trufaya's family over because it did not appear that Mr. Trufaya was wearing a seatbelt, despite the fact that he was fully buckled by the time the officer approached the vehicle. With the exception of New Hampshire, every state in the United States has some sort of seatbelt law. The majority of these laws, including the seatbelt law in Texas, are so-called primary enforcement laws that allow law enforcement officers to stop vehicles solely due to an observed seatbelt violation. However, as of the date of this episode, 15 states have so-called secondary enforcement seatbelt laws in effect that prohibit a police officer from stopping a vehicle exclusively on the basis of a driver or passenger not wearing their seatbelt. In these states, officers can only write tickets for seatbelt violations if they have lawfully pulled the vehicle over for another traffic offense. For instance, Section 4513.263 of the Ohio Revised Code, which is the state statute requiring drivers and front seat passengers to wear seatbelts, states that, quote, no law enforcement officer shall cause an operator of an automobile being operated on any street or highway to stop the automobile for the sole purpose of determining whether a violation of this section has been or is being committed, or for the sole purpose of issuing a ticket, citation, or summons for a violation of that nature, or causing the arrest of or commencing a prosecution of a person for a violation of that nature. And no law enforcement officer shall view the interior or visually inspect any automobile being operated on any street or highway for the sole purpose of determining whether a violation of that nature has been or is being committed. According to Section 545.413 of the Texas Transportation Code, quote, a person commits an offense if the person is at least 15 years of age, is riding in a passenger vehicle while the vehicle is being operated, is occupying a seat that is equipped with a safety belt, and is not secured by a safety belt. Because Texas is a primary enforcement state, courts have consistently held that officers can initiate traffic stops because a driver or a passenger is not wearing their seatbelt. For instance, in the 2019 case of United States versus Perez, the United States District Court in the Western District of Texas El Paso Division held that an officer, quote, had reasonable suspicion to perform a traffic stop for the seatbelt violation when he, quote, saw a passenger in her vehicle not wearing a safety belt in violation of Texas Transportation Code Section 545.413. Likewise, in the 2014 case of Galbatz versus State, the 9th District Court of Appeals of Texas upheld the reasonableness of a traffic stop where the officer, quote, personally observed that the passenger riding in the back seat was leaning forward and it appeared he was not wearing a seatbelt in violation of Texas Transportation Code Section 545.413 because, quote, a violation of the vehicle safety laws is sufficient authority for an officer to stop a vehicle, and, quote, it was not necessary to show that the passenger was not actually wearing a seatbelt, but simply that the trooper reasonably believed that the passenger was not wearing a seatbelt. In this situation, if a court accepted the officer's testimony that he did not think that Mr. Trufaya was wearing a seatbelt, it is highly likely that it would conclude that the traffic stop was constitutionally justifiable. And because it is possible that Mr. Trufaya buckled his seatbelt after the initiation of the traffic stop, a court could also determine that the continued detention of the family to write a citation or warning was also legally permissible.
And that's what's good about for you. You do get the right. If I write you a citation, you do have the right to go to the court.
Sir, that's a waste of time.
That's okay. You have the right to refuse.
Yes.
Okay. And what you're doing at this point is you're refusing to give me the information that's necessary to check you out, to give you a citation, or to give you a warning for what's occurred. That's it.
Why wouldn't you just do that? Can you just do that then? Would that work?
Yes,
Since I don't have
ID? No, I don't need your ID if you give me your name, number, and date of birth. That's all I need. It's not my fault that you won't help me out.
It is your fault, sir. There's no reason
Just make
for
sure you're
this.
seatbelted in the vehicle in case for some reason, unfortunately.
And that's what I was doing. You're saying I was hiding from you or putting my seat back. And you said that I had my seat back. All I was doing is making sure he stayed in his seatbelt.
I'm talking about.
I'm talking about in the car as well.
You didn't have a seatbelt on.
That is not
That's
true.
exactly how it works, just like it
That
now.
is not true. I don't roll ever without a seatbelt. So you're making up stories, sir. That's all you're doing. This is your discretion right now, sir.
Absolutely.
It is your discretion,
My
and you have the right to
once
let me
you
get
give
home to
your
my
information,
family.
It's my discretion to write you a citation or not.
How can you write a person that's not driving a citation, sir?
Because you're traveling down a public highway. That's the law. So this is where it can get even more negative, okay? Because I'm asking you to step out. If you don't want to step out, I don't have a problem you not stepping out if you'll give me the information. But if you're going to continue arguing with me, then you need to step out here so we can have a conversation out here. I don't trust
Sir,
what's
you're
going on.
using
I don't
bully
like how you're
tactics.
acting.
My hands are
I'm
right here.
concerned of what's in the
Everything's
car.
on video,
So
and you're the
that's
one
fine.
violating the
There's
Constitution,
video
sir.
all over. It's wonderful. You can sit here for a moment. You're not free to go, by the way.
I would really like to
So
be
you're
able to
saying
go,
no,
sir.
you're not going to do it.
I'm telling you that there is
So do you
no...
want me to pull you out of the car and arrest you? Is that what you want?
For what grounds? What have I
Because you're
done?
failing to ID yourself.
That
to
isn't
me
a
when
that isn't
when
a crime, sir.
The officer threatens to arrest Mr. Trufaya for refusing to identify himself, and Mr. Trufaya argues that it is not a crime for him to do so. Under Section 38.02 of the Texas Penal Code, quote, a person commits an offense if he intentionally refuses to give his name, residence address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. The statute also states that, quote, a person commits an offense if he intentionally gives a false or fictitious name, residence address, or date of birth to a peace officer who has lawfully arrested the person, lawfully detained the person, or requested the information from a person that the peace officer has good cause to believe is a witness to to a criminal offense. Therefore, the Texas Stop and Identify statute does not criminalize an individual's refusal to identify themselves when they have been lawfully detained, only when they have been lawfully arrested. Additionally, the state's interference statute does not prohibit the mere refusal to identify. According to Section 38.15 of the Texas Penal Code, quote, a person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Nonetheless, the statute explicitly states that, quote, it is a defense to prosecution under this section that the interruption, disruption, impediment, or interference alleged consisted of speech only, and, as the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, explained in the 2020 case of Voss versus Good, quote, merely arguing with police officers about the propriety of their conduct falls within the speech exception to Section 38.15, and thus does not constitute probable cause to arrest someone for interference. The court then went on to clarify that, quote, failing to comply with an officer's instruction made within the scope of the officer's official duty and pertaining to physical conduct rather than speech can also constitute interference, as well as, quote, actions such as making physical contact with any of the officers or physically obstructing them from performing their legally authorized duties. Because the officer's order that Mr. Trufaya identify himself was an instruction pertaining to speech rather than physical conduct, a court would likely conclude that Mr. Trufaya did not violate the interference statute for refusing to provide his name and date of birth to the officer. However, as we have discussed many times here on ATA, the Supreme Court determined in the 1997 case of Maryland versus Wilson that an officer may lawfully order a passenger to exit the vehicle during a traffic stop. And because the officer's order that Mr. Trufaya step outside of the car was, quote, pertaining to physical conduct rather than speech, a court would probably determine that Mr. Trufaya could be arrested for interference for refusing to exit the vehicle.
Anything that you're
it's a Class
thinking
C violation,
for
so
what?
It doesn't mean for not wearing a seatbelt.
I was wearing
it's
a
not-
seatbelt.
It's not like, and I told you, I'm not even going to write you a
You
citation.
don't care
I'm
about
gonna
the
give you a warning.
seatbelt, sir. I know
Absolutely,
what you're
100%
doing
I
here.
care about-
I
what
know
am I
what
doing
you're
then?
looking at me.
Educate me.
We haven't committed a crime. You're not saying you suspect us of a crime whatsoever, and yet you're holding us on the side of the road for no reason with a toddler,
I
sir.
absolutely
I'm
have
begging
all
you
the
to
legal
please
right
let
in
us
the world
go.
to do this. I'm starting to lose my patience with you,
Sir.
because you're not following the lawful orders I'm
I
asking.
am,
you.
sir.
And
You're
again,
using
I'm
bully
not-
tactics,
no,
sir,
they're
to
not.
try to get me to
And I have
violate
no
my rights.
problem opening the door and pulling you out of the car and taking you under arrest. Now,
Under what
I'll
grounds?
happily take you in front of a judge. When you sign the citation, it makes it very clear.
I'm happy
It
to
doesn't
sign a
mean you're
citation to
guilty.
show up in court, sir.
Okay, awesome. I
Cool.
gotta have your information though.
No, you don't.
How are you gonna? How do I know?
I'm not
who's coming to court?
driving.
Okay, so you want me to take your daughter's information? I'll take her driver's license then, if that's how it's gonna work.
You're violating my
so
right.
I can piss. I really don't care.
all I'm trying to do is
I'm
just
shaking so bad.
You
I'm
don't
about
even
to
have the
piss
right to ask
myself.
her, dude. Here,
Oh, I
here,
don't.
here.
Oh, so now
Give that
so
to
now
him. I'm
doing
not
what
giving
you
it
asked
to
me
him.
to do, and it's not good.
She's giving you her license, sir.
Oh, okay. I'm just curious. Now I'm doing what you asked me to do, and that's a problem.
I didn't
That's
say
the
I had a
issue with
problem with
individual
you.
like yourself,
I'm
sir.
silent,
Oh,
sir.
you're silent. You're still talking. Mouth's moving.
The officer takes Mr. Trufaya's daughter's driver's license so he can issue a warning to her for the alleged seatbelt violation, and Mr. Trufaya argues that the officer does not have the authority to check her driver's license either. Under Section 521.025 of the Texas Transportation Code, quote, a person required to hold a license shall have in the person's possession while operating a motor vehicle the class of driver's license appropriate for the type of vehicle operated, and display the license on the demand of a peace officer. As the Supreme Court summarized in the 2015 case of Rodriguez versus United States, quote, beyond determining whether to issue a traffic ticket, an officer's mission includes ordinary inquiries incident to the traffic stop. Typically, such inquiries involve checking the driver's license, determining whether there are outstanding warrants against the driver, and inspecting the automobile's registration and proof of insurance. Courts have long held that these additional inquiries are constitutional during a valid traffic stop because, quote, these checks serve the same objective as enforcement of the traffic code, ensuring that vehicles on the road are operated safely and responsibly. Given this precedent, it seems likely that a court would conclude that the officer could constitutionally require Mr. Trufaya's daughter to display her driver's license, even though the traffic stop was initiated based on Mr. Trufaya's alleged seatbelt violation. However, it should be noted that courts have consistently held that it is constitutional for an officer to request that someone identify themselves, whether they are lawfully detained or simply walking down the street.
Oklahoma? Where are you guys coming from?
We just came from Dallas.
From Dallas,
Back
okay.
to Oklahoma, yes.
I'm sorry, ma'am.
Back to Oklahoma.
Is there family in Dallas that you were
Yeah,
visiting?
we had family, friends.
Okay. You know, I really appreciate you working with me. That's all you've got to do. So, ma'am, what I'm going to do is I'm going to go back here and I'm going to sit in my vehicle and I'm going to write you out a warning, okay? And I'm going to specifically state on there that it was actually the passenger that would be receiving this warning, but unfortunately he's not complying, and then that you were very polite and went ahead and complied and gave me the information. So
Okay.
I'll be right back with you, ma'am.
Thank you.
If for any reason you'd like to call, or if this gentleman would like to make a complaint, there's the phone number right there you can contact. Here you are, ma'am.
Thank you.
I appreciate your cooperation and courtesy, ma'am, okay? You're free to go.
After issuing a warning to Mr. Trufaya's daughter for Mr. Trufaya's alleged seatbelt violation, the officer allows the family to leave. It is unknown whether Mr. Trufaya filed a complaint or pursued any legal action following the interaction. Overall, the officer gets a B+ for threatening to arrest Mr. Trufaya for refusing to identify himself without the legal authority to do so, and wasting valuable law enforcement resources on a non-existent, or already corrected, seatbelt violation. This encounter demonstrates the broad authority to detain and question individuals bestowed upon officers by primary enforcement seatbelt laws, and the way courts have interpreted the Fourth Amendment's prohibition against so-called unreasonable seizures. Although it appears probable that Mr. Trufaya was actually wearing a seatbelt at the time the officer stopped the vehicle, a Texas court would likely uphold the constitutionality of the traffic stop based on the officer's testimony that it, quote, looked like Mr. Trufaya was not wearing a seatbelt. That being said, what is reasonable for constitutional purposes often does not equate with what is reasonable in the everyday sense of the word. And in my opinion, it was neither reasonable nor an effective use of police resources for the officer to continue to detain Mr. Trufaya's family once he discovered that he was, in fact, wearing a seatbelt, at least by the time he approached the window of the vehicle. Mr. Trufaya also gets a B+, because although he demonstrated some confusion regarding the nuances of the constitutional limitations on traffic stops and refused the officer's lawful order to exit the vehicle, he confronted the officer about his irrational behavior and refused to identify himself when he was not legally required to do so. I commend Mr. Trufaya for his courage, and although he may have refused a lawful order in the process, he firmly defended his constitutional rights and did not waver, even under threat of arrest. Although Mr. Trufaya is not an auditor, he clearly has an interest in the Constitution and defending his rights against police overreach, and I would encourage him to continue to learn more about the U.S. legal system and what courts have said officers can and cannot do during a traffic stop. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.